Hello everyone, welcome to the literary and jury charge for the 140 class. We're going to start out with some challenging material on property. Okay, here we go. Ready? Property is the right and interest which one has in anything that is subject to ownership. Property may be tangible or intangible, visible or invisible, movable or immovable. Any person possessing property normally has the right to possess, use, enjoy, and dispose of it. A right to property is not always exclusive, but may be held by more than one person. Property is classified in terms of the nature of the property interest as real or personal. Real property is normally land and all things affixed to it. Generally, real property is tangible, immovable, and visible. Real property may include land, houses, trees, and buildings. Personal property is generally defined as movables. Personal property is sometimes defined as all things that are not classified as real property. Personal property may include the following items: clothing, automobiles, jewelry, furniture, and appliances. Intangible property includes goodwill, aesthetic value, and in some cases, works of art and music. In most instances, intangible value is subjective value. Okay. I have some jury charge for you. The subject is general jury charge. Here we go. Ready? Ladies and gentlemen of the jury, the written instructions now being given will be made available to the jury room during your deliberations. They must not be defaced in any way. Some of the instructions may be changed with writing or handwriting. Blanks in the printed instructions may be filled in by actual handwriting. Also, portions of the instructions may have been deleted by lining out. You are not to be concerned with the reasons for any changes that have been made. Also, you must disregard any deleted part of an instruction and not speculate either what it was or what is the reason for its deletion. Every part of an instruction is of equal importance. You are to be governed only by the instruction in its final form. If in these instructions any rule, direction, or idea be stated in varying ways, no emphasis thereon is intended by me, and none must be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and are to regard each in the light of all the others. The court has endeavored to give you instructions embodying all rules of law that may become necessary in guiding you to a just and lawful verdict. The applicability of some instructions will depend upon the conclusions you reach as to the facts. As to any such instruction, the fact that it has been given must not be taken as indicating an opinion of the court that it will be necessary or as to what the facts are. If an instruction applies only to a state of facts, which you find does not exist, you will disregard the instruction. Okay, I have an article here. This is called A Judge Who Lets Them Go. Okay, here we go. And it says here, does he have a soft heart or a soft head? Ready? Judge Lawrence seems to have a soft spot for people who commit nasty or stupid acts while under the influence of booze. Last February, the Chicago judge heard the case of Michael Coella, 28, a muscular thug who had mauled a female police officer when she stopped him for going the wrong way on a one-way street. She later needed the services of a plastic surgeon. Coella's lawyer came up with a novel explanation for why his client had disfigured the lady's face with his fists and a metal bar. His defense, a tattooed stranger in a bar, may have slipped a mysterious chemical into his drink. As a believable excuse, it ranked with the classic, "The devil made me do it." Coella was no stranger to police or trouble. In fact, he has achieved quite a history as a brawler and head basher. There was a time, according to the Norridge police, when Coella didn't like the way a guy on the street looked at his date, so he did a little punching and stomping. A judge then put him under court supervision. The River Forest Police know him too. He was in a restaurant when another diner did something to offend him, so Coella proceeded to bash the customer. When the police arrived, he wrestled with them and threatened to kill one of the officers. Coella was charged with assault and resisting arrest. The case was still pending when this article was written. Down the road, in Schiller Park, they also know Coella. He once got angry at a motel keeper because his car was damaged in the motel parking lot. The police say he didn't hit the man. He merely promised to kill him and blow up the motel. Because the motel keeper did not press his assault case, the charges were dropped. Judge Lawrence did not have any of the details of Coella's record before him, but the judge did have Coella's amazing defense that a mind-altering substance may have turned him into a raging beast, causing him to smash a policewoman in the face with a metal bar. So what did the judge do? Without a word of explanation, he found Coella not guilty. Now I have come across another example of Judge Lawrence's kindness. Let us jump back to the night of January 2nd, 2004, when John Morrison, 62, of Palos Heights, was driving his car on Chicago's South Side. His wife, Ella, was sitting next to him. Suddenly, a car veered across 4 lanes of a 6-lane street and slammed head-on into Morrison's car. Ella died instantly of massive brain damage. John had head and chest injuries and a broken arm, but he lived. The driver of the other car, James Veravic, 32, was only slightly injured, but a blood test showed that he was drunk. A trial was held, and Judge George Lawrence found him guilty of reckless homicide. All things considered, Viravec got a light sentence. He couldn't drive a car for 2 years, and he'd have to spend 60 weekends in the county jail. That way he could continue to work at his job. If you add it up, 60 weekends comes to about 4 months in jail. Not too harsh a punishment for getting drunk and killing someone. But not long ago, Viravec and a lawyer filed a motion to have his sentence reduced. He had spent 45 weekends in jail and asked that the last 15 weekends be scratched. The motion was assigned to Judge Lawrence. The assistant state attorney promptly objected to Judge Lawrence's hearing the motion, since he hadn't handled the original trial. But Judge Lawrence said, "I have jurisdiction and I'll entertain it." Then the assistant state's attorney said he wasn't prepared for a hearing. He wanted time to gather and present the evidence from the original trial, which he hadn't been involved in. Lawrence turned him down on that too. So the assistant state attorney asked for a delay in order that somebody from the dead woman's family, such as her daughter, could be present. To that, Judge Lawrence said, "I don't know that anybody has any standing or any proper place in a hearing of this nature at this point." Not being a lawyer, I don't know if the judge was correct, but even if he was, simple courtesy would allow for somebody from the family of Ellen Morrison to be in court when the man who killed her requests that his already soft sentence be made even softer. The family has no standing. If anybody has any standing, it ought to be the man whose wife was so violently taken from him, or their daughter, an only child. If nothing else, somebody from the family should at least have the privilege of sitting in the courtroom and giving dirty looks to the drunken driver. But Judge Lawrence didn't think their presence was necessary, nor was any evidence from the original trial necessary, not even a review of the transcript of the trial. In walks a guy who says he doesn't want to spend any more weekends in jail, and that's enough for Judge Lawrence. At the end of a hearing that lasted only minutes, Judge Lawrence said, "The petition to modify the defendant's sentence is allowed." I said that the judge appears to have a soft spot in his heart for people who do stupid or nasty things when they get drunk. I should change that. The soft spot appears to be in his head. Okay, interesting. All right. I'm going to read some closing statements. Okay. Here we go. On the 8th, those 3 critical discoveries that we talked about, that is, the Toyota key being found in Brian Stowe's bedroom. The SUV plates are found at that time, and the burn area is discovered, which, contains those human remains. The 9th becomes a very important day as well. This is the day that Brian Stowe is arrested. Brian Stowe is arrested for a weapons charge. On the 9th, he is then interviewed. But what you will also hear about the contact on the 9th is that the officers take some photographs. They do a physical examination of Brian Stowe, and they find a cut on him that you will see in just a few minutes. On the 10th, the burn area is further examined. On the key itself, on the key that was found in Brian's bedroom, they find his DNA. We will talk about that in a little bit further. On the 11th, the victim's blood, that is the female blood from within the SUV. Remember the big pool or the big stains in the cargo area in Sabrina's SUV? Well, those now match a soda can that Sabrina had up in the front of the vehicle. It's then presumed that to be of Sabrina Helms. So those are the first 8 days or so of the investigation and what you need to know. Again, that's probably, 2.5 or 3 weeks, or could be, of testimony that, in this case, we are going to try to fit into a layer of evidence. Try to fit into about 2 days, or maybe 2.5 days. So it is going to go quickly, but it is meant to give you a flavor of the size of this case, the scope of this case, and also to the credit not only of the Helm family and to the memory of Sabrina, but you need to hear it. You need to hear the whole story of the investigation. We talked about the development, the DNA matches that Ms. Calhoun developed at the crime lab. You're going to hear that Sabrina's blood later positively was identified to a standard area in the cargo area. Okay. I'm going to read to you from the Evolution of Monstrosity. And again, I like to always let students know that sometimes it can be disturbing, but because you are possibly going to be working in court one day, you need to get used to hearing that in school, okay? So just like we'd read in this other case, I mean, this is a true case, and you're going to hear about people, being murdered, unfortunately, and other graphic details. So that's why I like to, give you a variety so you get used to hearing everything, okay? So I'm going to start with the Evolution of Monstrosity, but I'm going to just read you the first paragraph, and then it goes into actual people in the past that have committed murders, like Jerry Brudos, the fatal shoe fetish, and there's some other ones as well. Okay? All right, here we go. Ready? Lust killers often have an ideal victim type in mind, with fetishistic elements, type of footwear or clothing worn, color or style of hair, body shape, a cheerleader type, or a slutty type, and so on. Lust killers often need intimate skin-to-skin contact in their killing and use a knife or strangulation to murder. Necrophilia is a very frequent aspect of lust killers or lust killer homicides. They are mostly highly organized having gone through years of the process of transforming and rehearsing their often bizarre fantasies into reality. Lust killers are often aware that their victim choice is visible to police and may choose to travel to various jurisdictions in both their hunt for and disposal of victims, because sometimes these killers consume certain body parts or focus on them. Dismembered victims might be spread over different locations. The lust killer usually chooses different dumping grounds for each victim, unlike the power control killer, who might like to keep his victims' corpses together at a choice location. Okay, so we're going to stop there. That concludes our literary and jury charge for the 140 class. Have a great day.